All right, well, let's get it started. I'm Will Trachman. I am the General Counsel at Mountain States Legal Foundation, and welcome to the next in our So a Neighbor Asked series. Today we'll be talking about how DEI and DEI specifically in the aviation industry affects your safety. And we have two very special guests with us in order to talk about that topic. Before I dive into their bios and the webinar for today, I do want to remind people that there is a Q&A box on the bottom of your screen. So we will do questions probably for the last 10 minutes or so of our webinar today. And so if you have a question that either you already have now or that arises during the course of the webinar, feel free to put it into that box and I'll see it and I'll ask it of our presenters so that you can have your question answered. With that, let's dive in. We've got two guests with us here today. Sean Nation is Mountain State's Deputy General Counsel. He has been working on the Brigida matter for just about a year now. He is a class action attorney by trade, and we're glad to have him as leader of the Brigida matter from the Mountain State's perspective. He's been doing yeoman's work on the case, which was filed even before he arrived here. And we also have Johanna Weber, who is an attorney at the law firm of Cooper and Kirk. Cooper and Kirk joined Mountain States as co-counsel late last year in 2023, and it has been doing incredible work on the case since then. Johanna lives in New Jersey. She went to Indiana University for undergrad and Harvard Law School. And I think New Jersey probably has at least one hill or mountain so that we can legally have you on our webinar. Perfect. Well, excellent. They are both here to chat with us about DEI in the aviation industry and how it's affecting your safety. Johanna, do you want to start us off and talk in broad terms about what DEI is, what makes it legal or illegal, and then how it interacts with the Brigida matter?
Sure. So thank you for having me. It's a real honor to be here. I very much appreciate the work that Mountain States does. You give us hope over in the East Coast. I think that, New Jersey is a wonderful state, but we have a lot of issues that have been brought upon us by the government. And so we are very happy for the work that you do. I think that the easiest way to say it is DEI is a matter of what your priorities are. And I think it's uncontroversial to suggest that the Biden administration largely reflects the Obama administration in terms of its priorities, a lot of the same people, a lot of the same ideas. So I think that this can kind of give you a snapshot of what it is in terms of both administrations. On his very first day in office, President Biden signed an executive order in which he directed the whole of the federal government to advance an ambitious equity and racial justice agenda. That's the White House's description. It says advancing equity is not a one-year project. It is a generational commitment. So it's obviously a very, very high priority in terms of what it is exactly. I spent some time trying to understand what it is specifically in the aviation industry, because that's what we're going to talk about. This is, again, all on the FAA's website. It says, to lead the aerospace industry into the next century, the FAA must actively promote values of DEIA. So actually, it's they've added a letter, which our friends like to add letters a lot. Very trendy. So D is diversity, E is equity, I is inclusion, as A is accessibility. Now, I then decided to see what I could get in terms of definition within the aviation industry specifically, and I got a pretty good explanation from the California Aeronautical University, which gives a definition. Here's the definition from diversity. I wrote it down because I want to make sure I said it exactly. Diversity is about bringing together different people with their differences, whatever these differences may be. Equity realizes that each person or group has different circumstances and seeks to allocate the needed resources and opportunities to equal the outcome. So those are some pretty stark definitions. And I think it's just fair to say that those are the priorities that this administration and the Obama administration are aggressively pursuing.
Yeah, I've also seen belonging as one of the letters in the acronym, and I think I might have even seen LGBT status. So I think it looks close to like Diablo if you added them all up together, which I thought was ironic. Um, Sean, let's turn to you. Talk a little bit about your arrival at Mountain States as a class action attorney, and then your involvement in the Brigida matter from the start to now.
Yeah, sure. So my background is actually mostly in antitrust type class action. So big, complex class actions, and this is certainly the Brigida matter is certainly of the type. Brigida is the name of our lead plaintiff, and I came in at the end of May, so 9, 10 months now, and really just jumped headfirst into the Brigida matter. Which is involving air traffic controllers, right? And it was a move away by the Obama administration from a merits-based hiring. So purely on the basis of how can you do on these specific tests that were designed to test for acumen at being an air traffic controller. Towards a racially based, they called it a biographical questionnaire that was designed to alter the racial makeup of air traffic controllers. And thinking about it, flying airplanes and flying on airplanes as a passenger is actually one of the safest activities you can do. And it's because historically we've only hired pilots and air traffic controllers and ground personnel on the basis of their merits. And unfortunately, we now have a massive shortage acknowledged by the FAA of, I believe it's approximately 2,000 controllers, 1,000 of which are represented in our class, who would have been likely to be successful air traffic controllers. And sort of bridge some of that gap. And unfortunately, what you're seeing from some of the overwork and the move away from merits is you're starting to see things like near misses. There have been a few high profile cases out of Austin Bergstrom International Airport, for instance, where a UPS or FedEx flight was about to land on a runway where a Southwest flight was taking off. And you can't have those errors. If you think about, those near misses, how devastating it would be to have, due to an air traffic controller error, 300, 400 people die simply because they're either overworked or they weren't selected due to their merits-based test. And that's not to suggest that, diversity as a concept is necessarily a bad concept, but in something where there's zero opportunity for error, that we contend, and I think is the right legal framework, should take a back seat to merit and to your ability to do the job.
Yeah, that's a great explanation. So, Johanna, let me turn it back to you. We've heard a lot about various federal civil rights laws and various titles. So there's Title IX, it covers sports, and Title VI covers education. What is Title VII, and how does it work with DEI? Because DEI programs are all over the place, so surely they can't all be illegal, right?
Well,
yeah. So I'm actually very excited about Title VII, and I think everybody should be very excited about Title VII because I feel like it is the statutory embodiment of the American dream in the employment context, the part we're talking about. So Title VII is the law one of the significant laws governing employment relationships. It's very broad. It applies to private employers with more than 15 employees. It applies to state, local governments. It applies to the federal government. In terms of employees, it applies regardless of citizenship status. It applies regardless of immigration status. So again, highly, highly significant. And the part that matters for today, it is, as the Supreme Court in a very significant case called Ricci versus DeStefano called it a promise. It is the promise that you are not going to be discriminated against because of your race, your sex, your national origin, or your religion. And I think it's worth, I think we forget, we tend to take for granted how radical that promise is in the course of human history. And I think it's worth remembering for a second. And again, I just want to commend Mountain States and organizations like it that really work to protect this. Throughout history, those characteristics pretty much defined what your life was going to look like. And then the United States of America came along and said, not so much. If your father was the biggest scoundrel in the world, you have the same right as the nobility to come in and ask for a job in a Fortune 500 company. We're going to give you that opportunity. It's very, very radical. It's very much worth protecting. Now, there are some nuances, some common sense nuances. The Catholic Church doesn't have to hire females to be priests. If Hollywood is going to do a historical drama, it's okay that people look the part, let's say. So there's some practical things, but generally speaking, that is the promise, that you're not going to be discriminated against for purposes of race, sex, national origin, or religion. Now, I would call the state of Title VII law right now a litigator's nirvana, because it's kind of a mess. You'd think that we would have it figured out by now, but actually we're so unsettled that even what decisions it applies to is up in the air. So the Supreme Court has in front of it is going to be hearing a case about, does it apply to a decision like a transfer? If you're transferred from one decision or department to another, does Title VII apply? We're not sure yet. The Fifth Circuit actually just decided a case that said it applies to scheduling. There was male deputies were allowed to schedule 2 weekend days off. Females were not because of any animus, but because they needed a female at the jail. And court said Title VII applies. So the question of whether it, what exactly it means is very murky. On top of that, I'll just briefly explain. The Supreme Court may have thrown an even bigger bomb in the whole thing with it this summer with a case, Students for Fair Admissions versus Harvard. Now, that is not a Title VII case, and we have to be very clear that that's not about Title VII. That was about whether the schools can use race as a thumb on the school. Can you get points for being a certain race? Basically, and the Supreme Court said no. It did cite several employment cases multiple times in its decision. And I think the way you know that it's on its way to having application to the employment context is there was this big kerfuffle in the aftermath. I think it was the day it came out, may have been the next day, but I think it was the day it came out. One EEOC commissioner said, this doesn't apply, go on your DEI way, keep going. Another one said, actually, those DEI programs were always unlawful, and let this be a warning to you that now they're going to fall because they're unlawful. Several Republican attorneys general sent letters saying, be on notice, these DEI programs are not okay. Several Democratic attorneys general sent a letter saying, actually, no, we're fine. And actually, you could get in trouble if you stop your DEI initiatives. Colorado attorney general issued an opinion that I kind of read to say lawful DEI programs can continue if they're lawful.
Right. And in the lawyer world, there were several law firms, big, prominent, top law firms in New York City or global law firms that would have programs where certain minority law students would get additional stipends above and beyond that wouldn't necessarily apply to certain non-minorities or to people who are ethnically Asian because they weren't the historically disfavored minority. And a lot of those law firms ended up abandoning those programs when they were challenged, typically via a letter from either a nonprofit or from a state attorney general. And if you think about it, yeah, that makes sense. Like, you shouldn't be drawing these distinctions based on racial stereotypes, which is ultimately what it comes down to, is racial stereotyping. And that is while we have an unfortunate history of race relations in the U.S., to move beyond that, you have to move beyond that. And that's, I think, where the Supreme Court is heading. It's certainly where I like to think society is heading. And I like to think that our courts will be reflective of that.
Yeah, well, Sean, the next question is for you, which is, kind of seems like an open and shut case. The FAA used race as a factor, and that's not legal under Title VII. So why has it taken us, I think we're going on our eighth or ninth year of litigation in this case. Why is it taking so long? And what does the FAA even say as to how this could possibly be legal?
So it takes, unfortunately, the court system does take time and does grind slowly. 10 years in a big class action is unfortunately not uncommon. And against the federal government, unfortunately, the courts tend to give them as much time as the government says it needs, which is unfortunately way too long in my opinion. But what the FAA says is the prior system was had barriers to minority access. So we were attempting to overcome those barriers and level the playing field. But they didn't. And it's very clear from the documents and from the things that they were producing at the time that they thought there were, quote, too many whites, is essentially how they would phrase things. And the way that the system that they had in place before is they would go through a college training initiative, the potential air traffic controllers. They would go to a college to become professional air traffic controllers. And they would take a test at the end of the day that was approved and that was created and verified by the FAA to have the lowest possible barrier based on race. And unfortunately, they tipped the scale in the other direction and decided, well, we're going to create a new test that correlates with certain minority achievement gaps, and put our thumb on the scale to have more minorities, and did so in a way that violates Title VII, and that's Title VII of the Civil Rights Act. So we are talking about civil rights, and we're talking about equal protection, the Equal Protection Clause of the 14th Amendment, which basically says the government's going to be neutral with respect to race. Hasn't always worked out that way historically, but in today's modern world, it works pretty well when the government just says, these are our standards, and we don't care what you look like. We don't care how light or dark your skin is. We don't care where your ancestors came from. We just want to know, do you hit these criteria? And if you do, you'll have an opportunity to do the job. And if you don't, then, let's find you something else to do. And unfortunately, the FAA, back under the Obama administration, decided that it did care where your ancestors were from or what color your skin was, and attempted to balance the pool of applicants on the basis of race. And we contend, and I think we will ultimately prove that that is unlawful, and the government can't discriminate in that way.
Yeah, absolutely. Johanna, I'm sure you've been following a lot of the media lately surrounding DEI issues in the aviation industry, and I think the side of a plane blowing out from one airline's plane. And then Elon Musk recently tweeted something about, could this be real with regard to our Brigida case being described on Twitter, what they now call X. Is there any reason why there ought to be diversity considerations in there? I mean, people say diversity makes us stronger, but it seems really obvious that it's not, that it's actually very dangerous. Do you have a take on some of the recent events or the media coverage and how it interacts with our work on Brigida?
Yeah, well, I think it's a complicated issue. So the FAA Office of Civil Rights their tagline, again, it's on the website, is achieving safety through diversity. And so you have to think through that. I think I don't want to have a knee-jerk reaction. If it were something like achieving safety through excellence, I could see it. If it were something like achieving safety through teamwork, I could see it. Something like achieving safety through diversity, I have a much more difficult time understanding why and how. And I hear what you're saying about the differences can make us stronger. And that is to some extent true. And I think the Students for Fair Admissions case got at this very well. The question is which differences matter and which do not, and differences of viewpoint and differences of what you've had to overcome in your life and differences of, of that nature can absolutely make us stronger. Can differences of skin color make us stronger? I would say no. And I think in terms of, if you want a really harrowing account of what is at stake here, the New York Times, which if you don't have a subscription, as you might not, I don't think this is behind a paywall. December 2nd did an investigation called Drunk and Asleep. And it was an expose. This was less than 3 months ago. It was an expose on the air traffic controller issues. And it actually went through both as Sean was mentioning, there's problems because there's a massive shortage, which is always going to cause stress and just anxiety and all kinds of things. And also there's reports of things like an employee physically assaulting others, sleeping, one admitted to drinking 9 drinks of vodka on her watch. So there's a big problem that I don't see how diversity would solve it. I'll just end with this. One of the most chilling lines for me was, again, I wrote it out because I wanted to make sure I remembered it. While the US airspace is remarkably safe, potentially dangerous close calls have been happening on average multiple times a week this year, the Times reported in August. Some controllers say they fear that a deadly crash is inevitable. Now, it's one thing to read about that in a New York Times article, harrowing. It's a whole other thing when it's your spouse on that plane, when it's your kid on that plane. And it is not going to matter that the FAA brought together different people with their differences, whatever their differences may be, when that moment's happened. And I pray it never comes to pass. But no, I don't see how racial diversity is going to avoid that crisis.
Yeah. Well, I do want to remind everyone on the line to go ahead and submit your question. We're going to be taking questions in about 10 minutes, and I want to give everyone an opportunity to ask our panelists for their thoughts on whatever topic you have on your mind. Sean, the next question is for you. As we talked about, the Brigida case has been going on a long time. Can you give us a status update and then maybe signpost the next few months to a year for us in terms of what's going to happen?
Sure. So the government just finished producing its documents. So it has certified that it is substantially complete. We are reviewing those documents, and that process takes time. We've got several 100,000 documents to go through, just to give you a sense of the volume of things. And it's anything from emails to official reports to potentially even chat messages between various government officials. We will then, in the coming months, start taking depositions, which are formal interviews of the people who were involved, potentially up to the administrator of the FAA, potentially, maybe the head of the Department of Transportation. We'll probably have to go to the court to get access to those sort of more senior folks, but we'll certainly be seeking that. The government has also shielded a bunch of documents through assertions of privilege, particularly deliberative process privilege, which we will be challenging in the coming months. Typically, when you're challenging a deliberative process, the government can't shield documents because of the deliberative process privilege, but that's a fight that's coming. Later in the year, we will likely have cross motions for summary judgment. Oh, I've left out expert discovery as well. The various sides will hire experts to produce expert reports, and then we'll question their experts. They'll question our experts. And then we'll have what are called motions for summary judgment, which each side says, here's why we win. The court will take that under advisement, may have a hearing. Often in a case like this, you may have a multi-day hearing with witnesses and evidence. And the court will ultimately decide whether there are triable issues of fact. While we'll assert that we automatically win, it's typical that a court would say, these are the claims I'm going to send to the jury. We have one overriding claim, which is a violation of Title VII, which I'm reasonably confident in the things that we've seen that we will be able to take that to a jury trial, which would likely occur at the end of 2025 into 2026. It's also possible the parties may engage in a mediation or some sort of type of settlement discussion. We haven't really engaged in any yet, but there's always a possibility. And which point the court would then give its blessing if we come to any sort of conclusion, which I don't know if we will or won't, but if this were a private entity, we likely would still not be in court, but it is the federal government. And one thing I did want to say that occurred to me as we were talking is this whole thing really involves racial stereotyping, and of a way that the Supreme Court described in the Students for Fair Admission case that Johanna mentioned, that it's just very outdated and very highly offensive to anybody who spends more than about 30 seconds thinking about it. So this is a really important principle that we're fighting for, and that is one of neutrality. So it is something, it's very near and dear to me, something that I'm very passionate about. And I really do feel privileged to be able to advocate for these would-be air traffic controllers who were denied just because they had the wrong skin color.
Yeah. Well, Johanna, you're the new folks. Cooper and Kirk just joined us last fall. First, had you heard of this issue before joining the case? And then what are your impressions of the case since you joined in terms of the need to stop the potential safety dangers that come from DEI?
Sure. Well, I'd heard of no, I had not heard of this case specifically. I'd heard, generally speaking, of some of the near misses, as Sean described them, which is what they were. And again, I'm not plugging the New York Times, but if you read this article, you'll get a sense of exactly what that means. They are truly near misses. So in terms of, I trust that justice will be done, and that will be a really good day for Mountain States and the people who they represent, who we represent, and the country, actually. And because I live in New Jersey, I have seen some of how DEI can mushroom, and how it is actually quite an insidious mentality, and it's certainly safety is an issue in this particular context, but it's really our identity as an American people that is at stake here. What do we care about? What matters? What are we going to teach our children? In New Jersey, all public schools from kindergarten through 12th grade, that's 5 years old to 18, they are compelled to incorporate DEI instruction in their curriculum. So they have to highlight and promote racial diversity, sexual orientation, race and ethnicity, religious, and as part of that, they have to examine the impact of unconscious bias. So 5-year-olds now, because the state has mandated that 5-year-olds in public school have to think about how they are racist and the effect that the 5-year-olds are having on their classmates because they were racist and didn't know it. So it's a far more global issue this is an incredibly important case, and I do believe that justice will be done in it. But it's important that it be done in it because it's emblematic of something far deeper.
Yeah.
Crazy.
I assume that the New York Times is the only publication that they get in New Jersey.
It's one of the few.
Yeah. No, and I'll plug one of Mountain State's other cases, which is Josh Young versus Colorado Department of Corrections. That's also a Title VII case, but instead of a direct discrimination case, it's a hostile environment case where Josh is a Caucasian prison guard, former prison guard, who was pushed out of the prison system because they told him, you're a racist, you're a white supremacist, as part of his official training, and he just couldn't take it anymore. So Title VII has a lot of applications, and these DEI programs are happening in very high-risk places, aviation, the prison system. These are places where if you get one move wrong, it's life or death. So it's very dangerous to adopt all these. We do have 3 questions so far. Just a reminder, if you have a question, to put it in the box. The first question is, I think, for Johanna, but Sean, feel free to weigh in. Is there any evidence that racial diversity has ever bestowed any distinct benefit in any endeavor anywhere? I think this is probably related to my question to you about whether, DEI and the aviation industry and whether diversity could make us stronger. Really, does it make us stronger anywhere? What do you think?
So the Supreme Court has carved out 2 exceptions. One is in military. So I was just saying before the call, I have three daughters at military academies, one at the Air Force Academy, go Air Force, 2 at West Point, go Army. And there is the sense that to be able to lead well, it's okay to consider race as a and diversity in that context. In other words, for the safety of, I don't know the case very well, but I think it's on the safety of prisoners. It was okay for guards to be of a certain race, and those make sense to me. Beyond those, I would be very hard pressed to think of a situation in which the color of your skin is in any way relevant or helpful.
Yeah,
I would say I think there was a time period right after the passage of the Civil Rights Act, and I grew up in the South, so I've seen and I grew up in a relatively non-diverse community, but having lived in the city of Atlanta and having seen how people can come together, I do think there was a time period where racial considerations likely would have helped to integrate society. Frankly, I don't think we're there anymore. I mean, we're 2 generations after the passage of the Civil Rights Act. But I agree, within the context of the military, I think integrating the military and attempting to promote people on the, into the officer corps, tried to recruit more minorities there, likely would have been beneficial. But I think in terms of the modern age, I think, I agree with Johanna, I'd be pretty hard pressed to find instances where today considerations of race would make us stronger, would be beneficial in any real way.
Yeah, that makes sense to me, because you can always imagine if the an employer or a government agency or even the military needs more people who are from a part of the country. You can focus on geographical diversity, or you can focus on socioeconomic diversity. You can factor in any number of things besides race.
Sure.
Race is a very blunt instrument, right? Because all you're doing is treating people differently based on their skin color, and any person can have any real experience in the United States, regardless of what they have in terms of background.
And if you think about it, we really, the way we define race in this country is really both overly broad and sort of under-inclusive. So, you're grouping in, a great-grandchild of a Mississippi sharecropper with a person who grew up in West Africa. And, those are very different experiences. Yeah. Same for, we call it Asian, but, that includes both South Asian, like India, Pakistan, and East Asia, like like China and Japan. And those are very different, very different backgrounds and very different potential experiences. So, if we're going to do it, I think maybe there needs to be more granularity somehow. That might be more effective, but I really don't see a way that you could do it that complies with the Civil Rights Act and the Constitution.
Yeah. This next question I don't want you to answer. I'll ask it, and you'll see why. If you could, however unlikely, settle this case before trial, what would it have to look like for you to agree to that settlement? I'm going to assume this is from the FAA, trying to ask us for our settlement position. With respect, I think we're going to decline to answer that question if this is not the FAA, just to not give away any trial strategy. But thank you for your question. The next question is, has the FAA changed any of their hiring policies since this case was filed? Or are they still going about using biographical assessments or personality tests or tinkering with their mechanism in order to get around the idea of, it being illegal under Title VII? Johanna, do you want to start us off, and then Sean?
Tinkering's a good word. Yeah, so there's been legislation in the interim, and whether that is effectively changed the approach, I'm not sure. Let me put it this way: the FAA continues to have things like inclusive language seminars. They continue to aggressively promote diversity initiatives, DEIA initiatives. So for now, it continues to be, I am comfortable saying, I think it might be the highest priority, but if it's not the highest priority, it is one of the highest priorities that the FAA continues to embrace.
Yeah, I would agree. And I would say at this point, it's unclear. And the FAA has resisted some of our efforts to delve into that. They were caught by Congress in 2016 as part of the reauthorization of the FAA's budget and told you can't use this biographical questionnaire anymore. In recent testimony, they've said they use personality tests and things of that nature, which could be a way of factoring in race, or it could be we just want to make sure you can get along with people in a high stress environment. So it's unclear, and we're trying to figure that out. And of course, if we're able to discover that they are still using race, we would want to have the court stop them from doing so.
Excellent. Next question is directly for Johanna. Any thoughts on how DEI might be harming military recruiting? I'll let you take that or pass, depending on what you want to say.
I genuinely don't have any thoughts on that.
Got it. Next question is, how should racial demographic groups that benefit from preferences feel about the fact that the government or an employer is saying you're so oppressed, you're so disadvantaged, the only way that you can succeed is with us giving you a helping hand? Is there a stigma factor? And could an African American have a legal claim against one of these diversity programs because I don't need it? The person would say, I don't need this, and all you're doing is stigmatizing me. I think I've heard of this effect in the medical industry where patients try to avoid African American doctors because the assumption is that they had a leg up through their schooling, regardless of whether that's true or not. They might not have. So what takes do you either one of you have on the stigma that might result from a racial preference?
So I think the question was phrased, how should a minority person feel? And I'm not going to presume to tell a person of another race how to feel about things. I do think that there is a risk of the sort of badge of inferiority, as it has previously been referred to, as affirmative action has previously been referred to. I know in my own personal life, fellow law students at NYU were concerned, minority members were concerned that there would be a perception that they could not get ahead without a preference. And these were kids who absolutely didn't need preferences. So, I do think there's a real risk and a real danger, but that's not, I'm not going to presume to tell another minority or a minority person how to feel about a specific policy.
Johanna?
Yeah, I agree with Shauna on that. I wouldn't know. I can't put myself in their shoes. I can speak to my daughter's experience though in the military, because it's a topic not an infrequent topic of conversation. They don't want to be viewed differently as women. Now, of course, there are some inherent differences. The men have to do a certain number of pull-ups, and the women have to do a flex arm hang. Although my daughter did as many pull-ups as the men, but that's, there's that. But there's other places in which that doesn't matter. They don't want to be viewed differently. They don't want to be given a pass. They don't want to be thought of as less than, because it affects the morale of the team, so to speak. And there's no trade-off benefit for them.
Yeah.
So that's the only experience I can speak to, but that's what it is for them.
Two more quick questions, and then I think we'll close out. The second to last question is: suppose there's a home run in Brigida. You get complete relief. The agency is prevented from ever using race in hiring. What is the precedential value of that decision with respect to all the other federal branch agencies and the Biden administration? And do they have to think, oh, we might also get sued if Brigida comes out the way that Mountain States hopes that it does? Either one of you for that one.
I'd say yes, that there would be a good precedential value for the use of race by any government agency. And specifically, I would say government agencies would have to make sure that their use of race is incredibly narrowly tailored to a specific program and specific need. So, let's say we go to jury trial and we get a complete verdict. I do think future administrations would have to think long and hard about using race in hiring.
I agree with Sean.
Yeah. Next question. This questioner says that some of the cases against the law firms have actually cited 42 U.S.C. section 1981 instead of Title VII. That's the provision that bans private race discrimination in contracting. Are we bringing that claim here? And do you folks have any idea whether that claim is becoming more viable or similarly viable as to with respect to Title VII?
The short answer is no, we did not bring that claim. Whether it's more or less viable, I don't know. I think Title VII is probably a closer fit. 1981 and all of those, I think it was the Civil Rights Act of 1868 is where those all come from. Those post-Civil War laws are very broad and I think can be very useful. But in terms of just this case and employment more generally, I think Title VII is probably a better fit.
Yeah, I think that's right. I mean, no, that's not a claim here. And you do often see Title VII cases reference 1981 just in terms of discussion, or 1981 cases reference Title VII again in discussion. But I will have to see how those cases play out in terms of the law firms.
Yeah, and the last thing we have is not a question. It's a comment from a former FAA aviation safety inspector who's with us on the line, who is remaining anonymous, saying that I would never want anyone in the aviation industry hired or retained on anything other than skill and merit, given the incredible safety risks involved. You always want the best person for the job. So whoever you are out there, thank you for your comment. And I think we'll close on that. Thank you so much, Johanna and Sean, for talking with us today. I appreciate your time and the time of all the questioners who presented excellent questions for our panelists. Keep in touch and watch out for our next email regarding March's So a Neighbor Asked webinar. We look forward to seeing you again soon. And thank you once again to our panelists and to Stanton for coordinating this. Thank you, everyone.
Thank you. Bye-bye.